So hello everybody and welcome to the first event of the day of the second edition of the Washington Arbitration Week. My name is Maria Lucia Casas and I'm part of the executive team and editorial team of this edition of the Washington Arbitration Week. I'm an associate at Strategy LLP, a boutique law firm based in Washington, D.C. and Bogota, Colombia. Strategy does investor state arbitration, international arbitration, as well as public international law. Today, I have the great pleasure to introduce to the moderator of this incredible panel, which is Jim Bird, who has been working immensely to put together this hot topic for all of our participants today. So Jim Bird is a partner at Fisher Bros in Washington, D.C. Jim is an international disputes lawyer. He's deeply experienced in the principles of establishing of defeating personal jurisdiction over foreign parties, enforcement on foreign judgments and arbitral awards, securing stays of litigation based on international arbitration agreements, and applying the forum non-convenience. Jean also handles disputes involving foreign sovereigns and state-owned companies under the Foreign Sovereign Immunity Act, and he assists in matters involving foreign investment, international trade, and U.S. finance sanctions. Jean also represents clients hailing from the energy, biotechnology, real estate, and finance industry, and he handles arbitrations under the rules of leading international institutions such as the ICC, LCIA, and UNCITRAL. He litigates cases involving international fraud and asset recovery, obtaining evidence in the United States for the use in foreign legal proceedings. Finally, Jim was retained by the U.S. International Revenue Service as an expert on Russian law and business practices to assist in and testify in court proceedings involving cross-border assignment of receivables. Jim served as an adjunct professor at Rogers School of Law, teaching international litigations in United States courts. And Jim, finally, speaks fluent Russian and is conversant in Ukrainian. So welcome everybody, and Jean, you have the floor.
Thank you very much, Maria Lucia, for such an extensive introduction. Appreciate that. I'd like in turn to thank the organizers of this conference, of this incredible conference, that the second edition of the Washington Arbitration Week. Ian Laird, who unfortunately is not with us today, and Jose Antonio Rivas, who fortunately we actually have on our panel, and I'll give a little bit more detailed introduction to him in a few more minutes. Let me turn to introducing speakers. Today we have star-studded panel. It's just incredible how lucky we are, how fortunate we are to get such a high-profile, experienced speakers who will reflect on the very important developments in the international law. And I'll introduce speakers in the order of their presentations. Certainly, first will be Professor Guido Carducci, who is a law professor at the University of Paris East. He is also an attorney at law in Italy, in Rome. And he is also international tenant and arbitrators at a 4-5 Gray's Inn Square, London. Professor Carducci is also a chartered arbitrator and a member of the ICC Commissions on Arbitration, Competition, and Commercial Law. Professor Carducci also former vice chair, International Arbitration and Litigation Committees of the ABA, former chief International Standards Section of UNESCO, in headquarters in Paris. He's got his PhD in International Contracts and Arbitration Law in the University of Paris 2, PhD in Comparative Contract Law, University of Rome 1, and diploma from Hague Academy of International Law. He's got extensive experience as an arbitrator in commercial, company, energy, investment, sports disputes. And he arbitrates, he does his cases in English, Spanish, and French, under the ICC Ancestral CAS ECA rules of experience as expert as expert in national EU international law in various areas. Next is Professor Nikos Lavranas. Nikos Lavranas is the first Secretary General of EFILA, founder of NL Investment Consulting, and guest professor at the Free University of Brussels. He's a co-editor of the book International Arbitration and EU Law, published this year by Elgar Publishing. I strongly recommend I started reading this book, and it's very, very interesting. He's listed as arbitrator as CATAC, VIAC, and several other arbitration institutions. He also consults and represents both investors and states in investment disputes. He combines his experience as arbitrator, mediator, legal consultant, academic, and former policymaker and chief negotiator for bilateral investment treaties. In addition to investment law and arbitration, Nikos also covers WTO law, EU law, and the interaction between public international law, European law, and national law. Nikos also established a Brexit Advisory Center to provide bespoke advice on the consequences of Brexit. Next speaker is Alvaro Galinda. Alvaro Galinda is the Dean of the Universitas de las Americas Law School and a partner as Carmillani Perez Law Firm in Quito, Ecuador. He's a member of the list of arbitrators on the ICSID Convention and a member of the ICC Court of International Arbitration. He's an arbitrator in several arbitration centers in the Latin American region. In his role as counsel and the arbitrator, he has acted in more than 50 international treaty and contract arbitrations. Alvaro is an adjunct professor at the International Arbitration Program at Georgetown University Law Center. And last but certainly not least is Jose Antonio Rivas, and I should say is the man, the myth, and the legend. He wears many, many hats today. Of course, one is the co-organizer who made this event possible, one of the people who made this event possible and created it. Second is he is just one of the, he was a co-moderator of this panel, to say the least, and he's actually a speaker on the panel as well, and we appreciate him sharing his experience. Jose Antonio is the founding partner of X Strategy in Washington, D.C. and Bogota, and chair of the Arbitration and International Law practice at X Strategy. Admitted to practice in the District of Columbia, United States, and the Republic of Colombia. He works as international counsel in investment disputes, serves as arbitrator, and provides advice in public international law and investment law to sovereign clients, state-owned companies, and investors. He has decades of experience in international investment arbitration and public international law. He represented sovereign states and private parties before the International Center, before the ICSID. So without further ado, just very brief introduction of the panel. The title of the panel is the EU Recalcitrant Entity, the case of domestic and regional judicial decision non-compliant with investment awards. The title reflects the developments in the EU law, and these are primarily developments of the EU law and how they impact the international law, how they impact the investment arbitration, and how these developments will be reflected, or maybe may get reflected during the enforcement proceedings, particularly in the United States, and also how these developments could be viewed if the similar developments are taking place, for example, in Latin America. That's something that Alvaro Galinda will be talking about. So there are different perspectives on what was happening in the EU over the past several years and how it's going to impact developments in international law. Just a few words about the organization of the panel. We will hear the speakers, then we'll plan for a brief Q&A session, and then there will be a 15-minute networking break where you will be able to speak one-on-one with our panelists, with our speakers. Um, Needless to say, all views expressed are private, should not be attributed to those respective organizations or law firms, and this panel is recorded. And without further ado, I'd like to start the panel. Professor Carducci, please.
Yes, thank you very much, Gene. Thank you. Good afternoon from Paris. Good afternoon or good morning from the US perspective. Thank you to organizers for the kind invitation. I have only 15 minutes, more or less, to deal with rather complex matters. The title is the EU a recalcitrant entity is a bit provocative. That's probably done on purpose. Why not? Nothing wrong with that. So I will try to use these 15 minutes being as much as I can clear and informative, because here, maybe not all of you, those listening or seeing this video, are familiar with EU law. So I'll try to provide as much as I can some background. So obviously, as any state, also EU member states are sovereign states. That goes without saying, which means that they are subject to international law. They interact under international law, both in terms of customary law and the treaty law. So they may commit, they enter treaties and commit under treaty law whenever they deem appropriate, like any state. Nevertheless, the EU is a highly integrated legal system. Therefore, member states do have a number of obligations under EU law and are expected to comply with those. Now, for the sake of clarity, I'll consider EU law from our perspective, which is only investment arbitration, first with regard to EU law, with the court. So judge-made, let's say judge-made EU law, because the court has a role in interpreting EU law. Then I will move to what member states have taken in terms of position they have taken. All of this goes back to 2018. So the part of the EU law I'm dealing with here is very limited. It's basically 3 years between ACMEA and today. So first, the EU Court of Justice. It is a court of justice, of course, so it settles disputes within its mandate, but it also provides an interpretation of the EU whenever the court of member states so require. And then it has jurisdiction for the interpretation of the treaties. So what used to be the Rome Treaty, now the TEU and the TFEU treaties, the two treaties, and also has jurisdiction on the validity interpretation of acts of the institutions, bodies, offices, or agencies of the Union. That's its mandate. Now, of course, all the rulings on interpretation and the two judgments I will be considering here, ACMEA and the following one, they are all addressed to member states, not to third states. They provide an interpretation of EU law as the court deems appropriate, of course, because it is the one providing the interpretation. And these rulings concern member states, not third states, concern member states and their organs, primarily courts. So a national court, a French court, a Spanish court, a Swedish court, and so on. Whenever they apply EU law, if on that issue of EU law there has been an interpretation provided by the court, it's just normal that that national court of a EU member state follows the interpretation given by the court. That's the context. We all know that international arbitration tribunals are generally presented as having no lex ferrae. So that differently from courts, international arbitral tribunals are not rooted in the legal system of the seat. That's what we generally mean by saying there is no lex ferrae in international arbitral tribunals. Nevertheless, it is a fact that under most legislations, the law of the seat of an arbitral tribunal is the law which governs the grounds for annulment of an award. So despite the absence, as a matter of principles, of the lex ferrae in international arbitral tribunals, nevertheless, we do observe, it is a fact, it's not an opinion, we do observe that under national legislation, arbitration legislation in most countries, the court of the seat of the arbitration may decide to annul, upon the request of a party, of course, may decide to annul the award on grounds that are based on national legislation. That's exactly what we're facing here, because we have in ACMEA, the first ruling, we had a situation in arbitration that originated in Germany. And then in Comstroy, the second war and the second judgment that we'll be dealing with, we have an arbitration based in Paris. That's why the issue was brought before the Paris Court of Appeal. So the first judgment, it's ACMEA. It's the famous court ruling dated 6 March 2018. It's very well known by all of us, all of you. Briefly, the court held that I'm just giving you the very final relevant, the most relevant conclusion of the court. Article 267 and 344 of the CFEU must be interpreted as precluding a provision in an international agreement concluded between member states, under which an investor from one of those member states may, in the event of a dispute concerning investments in the other member state, bring proceedings against the latter member state before an arbitral tribunal whose jurisdiction that member state has undertaken to accept. So to make a long story short, under Articles 267 and 344 are the EU law grounds retained by the court in its ruling in ACMEA to conclude that such both provisions preclude the operation of an arbitration clause in an intra-EU BITs. Okay, Article 267 is the one on the interpretation of EU law by the court, and at the other one, it's 344, which concerns the fact that member states undertake not to. I give it in extenso. Member states undertake not to submit a dispute concerning the interpretation or application of the treaties to any method of settlement other than those provided for therein. That's Article 344. Now, this is the court. This is the position of the EU court in 2018 in the famous ACMEA case. Now, what the arbitration practice, so arbitral tribunals, which of course are not member states of EU, are not organs, are not national courts of EU member states. If we look at the international arbitral tribunals seated in the EU, so seated anywhere in the EU, most of them, as far as the information is available, because we know that we have confidentiality as a principle in arbitration, then most of them have assumed jurisdiction over the dispute, despite the court ruling in ACMEA. Okay, now after ACMEA, we had another position taken by the court, but it is an opinion. It's 1117. I don't have the time. I'm just informing you that it exists. It goes back to 30th of April 2019. It is an opinion on the CETA agreement, so on the Canada-EU agreement and on its compatibility to EU law. Just to say that it exists, I don't have time to go through. I now then move to very quickly to Comstroy, which is the most recent judgment and a very important one, very recent, September the 2nd, 2021, Republic of Moldavia versus Comstroy LLC. It is again a ruling on interpretation. So we all know that it is a ruling that provides the interpretation of EU law given by the court to the attention of member states. Now, summarizing, again, I don't have time, unfortunately. Basically, is sale of electricity an investment under the Energy Charter Treaty? Question mark. This was the dispute. If yes, sale of electricity, it is to be regarded as an investment, then the consequence is that the arbitral tribunal had jurisdiction. The award is not to be set aside and all is fine in terms of arbitration. On the contrary, if the answer is no, a sale of electricity is not to be regarded as an investment, then the tribunal lacked jurisdiction, should have never assumed jurisdiction, and therefore the award may be annulled by a French court because the seat of the arbitration of the tribunal in this arbitration was actually in Paris, was an ad hoc arbitral tribunal, and then there would be an annulment of the award. There have been, I don't have time to go through, there have been two cases twice before the Court of Appeal, then the Court of Cassation. To make a long story short, the position of Moldova is that the arbitral tribunal should have declined jurisdiction from the beginning, precisely because the sale of energy is not an investment under the Energy Charter Treaty. The other position, Comstroy, submits, on the other hand, is that the same arbitral tribunal had jurisdiction in accordance with Article 26 of the Energy Charter Treaty and did meet the different requirements for jurisdiction to exist. The Court of Appeal basically decided in Paris. The Paris Court of Appeal decided to stay the annulment proceedings, so to suspend them, and to request a preliminary interpretative ruling to the court, what we already discussed. Now, the court, first of all, the European Court has decided to assume jurisdiction on the interpretation of the Energy Charter Treaty. We all know the Energy Charter Treaty is a multilateral treaty. Obviously, it is formally not EU law, because when we say formally EU law, it is law made by the formal sources of that legal system, okay? So if we say German law, it's law made according to the formal sources of Germany, like of any legal system. So it is not formally EU law, but anyway, the court has assumed jurisdiction for the interpretation. On what basis? On what basis? We find it here in paragraph 23. So I'm trying to be as accurate as possible within the little time I have. In paragraph 23 of the ruling, we read, it is apparent from the court's settled case law that an agreement concluded by the Council, so like the Energy Charter Treaty, which is not actually concluded, but nevertheless, pursuant to Articles 217 and 218 TFU, constitutes, as regards the European Union, an act of one of its institutions, that the provisions of such an agreement form an integral part of the legal order of the European Union. I repeat, that the provisions of the Energy Charter Treaty, I'm quoting, form an integral part of the legal order of the European Union from the time the Energy Charter enters into force, and that in the context of that legal order, the court has jurisdiction to give a preliminary ruling on the interpretation of that agreement. So this is the motivation, the main one. We find it here in paragraph 23. We also have other motivations, probably less important, from 24 up to 38. I don't have time here to go through, unfortunately. Now, what's the consequence of the fact that the court assumed jurisdiction as to the interpretation? Obviously, it did provide interpretation. So it tells us in paragraph 79 that like the state party to the proceedings submitted, a mere supply contract of electricity is a commercial transaction which cannot in itself constitute an investment within the meaning of Article 1.6 of the European of the Energy Charter Treaty. So that's the decision in paragraph 79, and therefore the conclusion is that by interpreting Article 1, paragraph 6 and 26, paragraph 1, as meaning that the acquisition by an undertaking or a contracting party to the treaty, etc., it is not an investment. Okay, it does not constitute an investment within the meaning of those provisions. So this is the outcome, very, very straightforward. That's the opinion of the court concerning how should the investment be understood under Article 1.6 and for the purpose of 26.1 of the Energy Charter. Now, at least we should observe, at the very least, that the court assumed jurisdiction to interpret the Energy Charter, but does not refer expressly to the Vienna Convention on the Law of Treaties, the famous Vienna 1969 Convention, and in particular never mentions the convention nor its famous provisions on the interpretation of treaties. So why that? The judgment does not stay. Is it an omission? I don't know, or at least the court does not say, or does, on the contrary, the court take the view that the Energy Charter Treaty is to be regarded as only within the EU and only for the purposes of its interpretation by the European Court? Is it to be regarded as no longer subject to the interpretation criteria of the Vienna Convention? We just don't know. These are hypotheticals. The court does not provide any information in the judgment on this very specific topic. Now, important for the sake of clarity, the impact of Comfroy, of this judgment, of this ruling on EU law and on the Charter Treaty is only between EU member states. This is an important point. We will probably come back back to this in the discussion. Important is paragraph 65 and 66. 65. It follows that although the Energy Charter Treaty may require member states to comply with the arbitral mechanism for which it provides in their relations with investors from third states who are also contracting parties to that treaty, as regards investments made by the latter in those member states, that's Article 26. Here is the relevant part. Preservation of the autonomy and of the particular nature of EU law precludes the same obligations under the ECT from being imposed on member states as between themselves. I repeat, preservation of the autonomy and of the particular nature of EU law precludes the same obligations under the ECT from being imposed on member states as between themselves. And the follow-up is provided right after in 26, paragraph 66, right after. In the light of the foregoing, it must be concluded that Article 26(2), paragraph 2, letter C of the Energy Charter Treaty must be interpreted as not being applicable to disputes between a member state and an investor of another member state concerning an investment made by the latter in the first member state. So we should be very clear. The court interprets the Energy Charter, and it's Article 26, as not being applicable only within the EU. So only in investment claims intra-EU, so between EU member states and investors of another member state. Of course, we are assuming that all member states are also parties to the ECT. Okay, they're also states parties. So basically, the logic is exactly like ACMEA. Comstroy and ACMEA, both rulings of the court, follow exactly the same logic. We deal here only with intra-EU BITs. We don't affect third states, so states outside the EU, and the ruling does not concern investors from outside the EU or states, parties to the ECT, of course, that are non-EU member states. That's the position taking, as far as we can tell, from the two paragraphs 65 and 66 that I've been able to bring to your attention. Okay, now I move very quickly to the position of states. So far was the position of the court, now position of member states. We all know that in terms of making treaties and terminating treaties, the actors, the doers, are states. We also know that international organizations under some conditions may conclude treaties, but of course 99% of treaties worldwide come from states. They are the actors in the world of treaty making. They do negotiate, they do adopt, they do ratify, and possibly they do terminate treaties. So it is just normal and also welcome that the member states have taken a position in all of this, because until then we had only the ruling of the courts. We only had ACMEA since 2018. Now, what is the position that member states have taken? We have two positions. They are consistent one with the other. The first one is declaration of termination by 23 member states. It dated 16 January 2019. They issued a joint declaration which confirms the judgment of the court in ACMEA and draws the following conclusions. The declaration does not affect the pre-ACMEA situations. It affects only from ACMEA onward. And basically, I'm summarizing. Since ACMEA member states lack consent, so any arbitration that is ongoing after ACMEA, so after 6 March 2018, is to be regarded as lacking valid consent to arbitration by the EU member states. The consequence is obviously that tribunals lack jurisdiction because the EU member state side was not able to consequence, obviously, so that the awards is to be annulled for lack of jurisdiction. Then we have more of that. I don't have the time. Then we come to the agreement. It is subject to ratification. It is basically a treaty, so it is binding. It's a different legal nature from a declaration. It goes back. It's after the declaration, and it is an agreement for the termination of bilateral investment treaties between the member states of the European Union. This is the title. So the agreement decides that member states, through the agreement, they terminate BITs. We all know that a state party to a treaty may, under public international law, primarily under Article 54 of the Vienna Convention, terminate treaties. That's what they do. And then the agreement applies only to intra-EU BITs, so does not apply to the Energy Charter or other multilateral treaties. And the content is very clear. There is a termination. Let's be careful. There is no termination of the old treaty, of all the provisions of a BIT. There is termination only of the arbitration clauses, the ordinary ones and what we call the sunset arbitration clauses. Both are terminated, but not all the remaining provisions of these BITs. Then there are a number of measures. Most importantly, for the pending arbitration proceedings, so those that are still not yet concluded at the time that the treaty enters into force after ratification by the state concerned, maybe Poland, maybe Italy, maybe France, and so on. From that date on, okay, then there are two measures important to be mentioned.
Professor Carducci.
May I have one more minute, Jen?
Thank you very much.
One more minute. First is that under the agreement, there must be a structured dialogue between the investor and the state in order to try to reach a settlement. And second, if the settlement is not reached, which may happen, of course, and then the agreement grants the investor access to the courts of member states, even if under the law of these states, there would be the claim would be barred because of time. So it is an interesting instrument. I just don't have the time here to deal with it. So basically, the court has changed the scenario dramatically by excluding reliance on arbitration clauses only in the BITs. We have that since ACMEA. Comstroy has confirmed that. Comstroy has extended its interpretation to the multilateral treaty, which is the Energy Charter Treaty. And its interpretation concerns national courts in EU member states. So like in the Comstroy case, if an arbitration takes place in the EU, in case a party seeks the annulment, that court may by now would follow the interpretation of the court as to the ECT, if the ECT, of course, is relevant. Otherwise not. Member states have been consistent. They've been following the position of ACMEA, of the court in ACMEA, and they decided to go through termination of the arbitration clauses only in the internal BITs. Thank you. I'll stop
Professor
here.
Carducci, yes, I think it was a very good introduction, very thorough and very detailed. Appreciate that. And while you were speaking, we already got several questions, and I'd like to ask Nikos Lavranos, of course, do his presentation, and perhaps he would also address some of the questions that were raised during Professor Carducci's presentation. Thank you.
Yes, thanks very much, and thank you for having invited me. It's a great pleasure and honor. And as you said, I really speak in my personal academic capacity and not in the capacity as Secretary General of EFILA, just to be very clear on this. Due to the time restrictions, I will come in immediately with my conclusions, and I will explain why the ECJ, I refer to it ECJ because CGU is difficult to speak out, why the ECJ acted ultra vires from a public international law perspective in Comstroy. My basic point is that the ECJ has thrown the arbitration provision of the ECT into doubt, not only for intra-EU disputes, as we heard, but also for disputes involving non-EU ECT parties. Effectively, non-EU investors, claimants, cannot use the arbitration provision of the ECT any longer in the EU without running into serious trouble. So we are talking about an extraterritorial overreach of the principles of autonomy and supremacy of EU law. In this way, the EU and its member states are not only recalcitrant, but are actually undermining the ECT and thus violate international rule of law principles. Indeed, they give a bad example for other countries, which now rely on the example of the EU to disregard their treaty obligations whenever they like by simply arguing that domestic law and domestic courts prevail. That's my conclusion. Let me zoom in now to the Comstroy judgment and the consequences of the Comstroy judgment. We heard Professor Carducci describing the limitations of the judgment to the intra-EU situation. But I will show you that you can definitely also see from a public international perspective that there is clearly also an extra EU dimension to the Comstroy judgment. This, as we just heard, applies first and foremost to the selection of the seat of arbitration. As we know, the default seat for ECT disputes is Stockholm, but other cities such as Paris, like in Comstroy, or Madrid, in the many renewable cases, are also often selected. However, the Comstroy judgment made clear that having selected a seat within the EU means that the domestic courts have jurisdiction for setting aside an annulment proceedings, in particular for non-ICSID disputes. That's an important distinction we have to make, which the court doesn't do neither in Achmea, neither in Comstroy. We have to make a distinction between ICSID and non-ICSID. Anyway, now the Comstroy judgment, which repeats the Achmea judgment, and I come to that in a minute, forces domestic courts, as we heard, to refuse to accept jurisdiction of arbitral tribunals seated in the EU, as they are considered incompatible with EU law, since arbitral tribunals undermine the autonomy and supremacy of EU law, according to the ECJ. Now, this brings me to the second issue of recognition and enforcement of ISDS awards within the EU. So for the same reasons, foreign investors are now effectively prevented from getting the awards recognized and enforced by domestic courts in the EU. Now, in short, the anti-arbitration approach established by Achmea judgment for intra-EU bids has now been extended with the Comstroy judgment to the ECT. That is, of course, not surprising. It is understandable that the ECJ wants to create consistency across the board as far as intra-EU ISDS proceedings are concerned, irrespective whether they are based on intra-EU, BIT, or the ECT. That's understandable. And that's also what the member states wanted. Remember that actually in the declarations, the majority of the member states extended the termination also to the ECT arbitrations. Anyway, but now I come to my main point, which is, and I want to stress this, is the problem with Comstroy is that it is not an intra-EU dispute as it was with Achmea. And why is that? Because it involves an Ukrainian company registered in the British Virgin Islands and Moldova. And this brings me to my main critique of the Comstroy judgment, namely that the ECJ equalizes the intra-EU bids with a multilateral agreement such as the ECT, which has more than 20 non-EU contracting parties. So when the ECJ stated in paragraph 64, and I'm quoting now, that it should be noted in this regard that despite the multilateral nature of the international agreement of which it forms part, a provision such as Article 26 ECT is intended in reality to govern bilateral relations between two of the contracting parties. And now it comes in an analogous way to the provision of the BIT in Achmea, and it refers to Achmea. And I think, in my humble view, I think that is legally wrong. And it's definitely legally wrong from a PIL perspective, from a public international perspective. While the ECJ may be correct by saying, in reality, we talk about a bundle of bilateral relations between two contracting parties. That may be a view. De jure, and that is what we are talking about, de jure, the ECT remains a multilateral investment treaty, definitely from a perspective of public international law. Therefore, in my view, the consequences of ACMEA, whatever they may be, and we heard Professor Carducci telling them, the consequence of ACMEA internally are not and cannot be the same for the ECT with regard or following from the Comstroy judgment. And I think this is really very important because the ECT is a multilateral agreement. So the ECT has a dual nature. It is a multilateral agreement, first and foremost, and only for internal EU purposes, right? It has also EU law characteristics, which means whatever the ECJ is saying, and here I'm concurring with Professor Carducci, whatever the ECJ is saying regarding the ECT can only be relevant internally, but it can diminish the rights and obligations of non-ECT parties and investors from Japan, UK, post-Brexit, Switzerland, or Ukraine for that matter. Next point. Also, the ECJ is not even mentioned in Article 26 as a competent court to authoritatively interpret the ECT or to diminish any rights or obligations as far as non-EU ECT members are concerned. But that is exactly what happened in Comstroy. There is no EU investor involved, and there was no EU member state involved, right? The only link with EU law was the simple fact that Paris was a seat of arbitration. And I think this is a very important point to make. So the comparison, the equalization between ACMEA and Comstroy from that perspective is legally wrong. Now, and of course, when you look at it, it means, like in the Comstroy case, that although you are a non-EU investor, and although you are bringing a case against the non-EU contracting party of the ECT, but the simple fact that you selected Stockholm, Paris, Madrid, Frankfurt, whatever, as a seat means that you cannot use the ECT anymore. And this diminishes the rights and obligations of those non-ECT parties, both those states and their investors. Now, a couple of months ago, we had the Paris Arbitration Week, and there were two state lawyers from Spain and Czech Republic at the Paris Arbitration Week, and some of you might have been there online, and they were already talking about how to implement, quote unquote, the Comstroy judgment. What does it mean? Will there be a termination agreement also for the ECT? Will there be a disconnection clause? We don't know, but it's interesting to see, will they withdraw? And I mentioned, of course, for instance, that Italy has already withdrawn from the ECT a couple of years ago. So it is not unlikely that this might happen. Actually, I think the EU, the European Commission, has already threatened to withdraw if the modernization process within the ECT doesn't go the same way. So what I'm trying to say here is that the EU and the member states, as I said, are not only undermining the ECT, but they are effectively diminishing the rights of others. And this is very sad because we should, and I take this a bit a broader approach, we should not forget that it was actually the EU and the member states who created the ECT. And unfortunately, even the Netherlands was a driving force behind the ECT, which I think makes me very sad. And we should think about the long-term effects. Final points. So what does this mean? In summary, investors, claimants should select a seat of arbitration outside the EU. Investor claimants should select the ICSID Convention as arbitration rules rather than the UNCITRAL arbitration rules in order to avoid any involvement of domestic courts of the EU member states and potentially the ECJ. However, and I bring in another case in our discussion, as the Mikula case shows, which concerned an exit award under the intra-EU BIT, even an exit award can run into trouble with EU law when it comes to the recognition and enforcement of that. And as we know, as we teach our students, the exit convention is a self-contained regime, and no court should get involved in the recognition enforcement aspect. Fortunately, as far as the Mikula award is concerned, at least the UK Supreme Court resolved this issue correctly in favor of the exit convention. So to me, the non-EU ECT contractor parties should make very clear to the EU member states and the EU that the judgments of the ECJ do not apply to them and cannot diminish the rights and obligations. And for this reason, the fact that suddenly these non-EU ECT member states are confronted with principles of supremacy of EU law, with concerns of the autonomy of EU law, with issues of control that the court in Luxembourg might have vis-a-vis arbitral tribunals, which it considers to be out of bounds of its control, are not issues that can be imposed outside the EU. But the fact is, as I tried to explain to you, that this is happening, and I hope this will be enough food for thought for discussion. I'm looking quickly to the questions, but we might take them in the order of our chair.
Nikas, I believe you did address this, at least the idea of these questions in your presentation, which was very candid, straight to the point, and I think was very clear. I really appreciate that. I think you really focused on the key points and the key issues with the Comstar decision. That's the focus of the discussion. Now, if you don't mind, I'll switch to Alvaro, and Alvaro will talk about what would happen if, what is the impact of Comstar decision of CJAU moves, other CJAU decisions, if that would be happening in Latin America, particularly in the Andean Tribunal. Alvaro, please go ahead.
Thank you, Jean. For your relief, I will try to keep my presentation shorter than the time that we have been provided.
Thank you for that.
For sure. And I would like to, of course, thank the organizers of this Washington Arbitration Week, and particularly to Jose Antonio Rivas, a dear friend and colleague with whom we have shared some different adventures in our past lives. Going to the subject of this discussion, when I read the theme of our panel, and particularly this very provocative, as Professor Carducci mentioned, theme of is the EU a recalcitrant state? It was kind of a deja vu for me when I was 15 or more years ago, the head of the international arbitration team at the Attorney General's Office of Ecuador. And at that time, Ecuador and other states in the Latin American region started to take actions against the investor-state dispute settlement system and the investment protection system in general. It was kind of ironic to see this question mark to the decisions that the EU, through its courts and the member states and the European Commission, is are taken. And I say this because at that time, particularly in the case of Ecuador, some commentators say that that was kind of a banana republic going against the system for the protection of foreign investment. So I see this coming now through against those who basically designed the system of the investment protection through bilateral investment treaties and other type of instruments under international law that now that are being attacked by foreign investors. Now they question the system that they created years ago. Under this premise, I think it's interesting to try to see what the impact of these measures that are being taken by the European Court of Justice and the EU Commission and other organs of the EU system in the relationship that other countries, and particularly developing countries from the Latin American region, have with the system. And I said this because, as you may be aware, Ecuador was the second state after Bolivia to denounce the ICSID Convention. There are only 3 states in the history of the ICSID Convention that have denounced the ICSID Convention. This denunciation took place in 2009, 12 years ago. It entered into force in January of 2010, according to the ICSID Convention. And Ecuador stopped being a member of the ICSID Convention for 12 years until recently, when the new administration in Ecuador, led by President Guillermo Lasso, decided to come back as a member state to the ICSID Convention. There was a shift in policies since May of this year with the new administration. And the question was whether Ecuador could re-enter the ICSID Convention without going through the National Assembly, the Congress of Ecuador, in order to ratify the ICSID Convention. And that question was solved by the Constitutional Court of Ecuador, which is the highest constitutional court in the land. And basically what the Constitutional Court of Ecuador decided was that under the Constitution, there was not a requirement for a previous authorization or approval by the National Assembly for Ecuador to ratify the ICSID Convention once Ecuador had signed such convention. Now, this scenario is not pacific. It is not something that has been solved, and there is not any more discussion. You may be aware that within the National Assembly has been taking some steps to question the decision of the executive and the conclusion of the Constitutional Court to allow the government to ratify the ICSID Convention without prior approval of the National Assembly. So this is a question mark still pending, and the same Constitutional Court has to decide the questioning that has been raised by the National Assembly. We don't know when or whether that question is going to be addressed at some point by the Constitutional Court, but there is a file that was initiated by the National Assembly before the National Court, before the Constitutional Court. So it is an issue that is still pending under Ecuadorian law. Whether that decision could have any effect or impact under international law, I would say it will not. This is something that under international law has been already solved. Ecuador is a member contracting state of the ICSID Convention since September 3rd, 2021. Now, how all these decisions in the ACMEA case and the Comstroy case under EU law could have an impact, particularly in the member states of the Andean Community region. I think it could have an impact, but the difference under the Andean Community law system with the EU law system is that the Andean Community Tribunal decided that arbitral tribunals can file requests before the Andean Community Tribunal in order to interpret provisions under Andean Community law that could have an impact on the decisions adopted by arbitral tribunals. So that's a big difference with what is going on under EU law. And that's an important point to bear in mind, because these interpretation proceedings before the Andean Community Tribunal filed by arbitral tribunals at the end could have an impact depending on what interpretation the Andean Community Tribunal could take. That's an important difference. Another point, which I think is important to bear in mind, is that in particular, under the current political scenario that we live in Ecuador, the approach has shifted, I would say, 180 degrees on how Ecuador is relating today with international law in general, and in particular with the international investment law system and ISDS system. Ecuador has announced that it will negotiate new international investment treaties, particularly through international trade agreements with Mexico and other countries of the Pacific region. It has announced negotiations with the United States to try to negotiate a trade agreement. So the approach of the current administration in Ecuador is very different of what we saw the previous 15 years. Another important message given by the administration of President Guillermo Lasso is the enactment of a new regulation to the arbitration law of Ecuador that has made very clear that the state and the state instrumentalities of Ecuador will be playing an important role both under international arbitration and domestic arbitration from now on. So I think that with this particular scenario, we can see that the decisions that have been adopted under EU law may have an impact under the Andean Community Region system, which you may already know, the Andean Community legal system is kind of the young brother of the European Union legal system, but it has its own particularities, as I have mentioned, and one important particularity is that the Andean Community Court gave a green light for arbitral tribunals to file requests for the interpretation of the Andean Community law applied in particular cases by international tribunals or arbitral tribunals in general. Thank you very much, Jim.
Alvaro, thank you very much. Really appreciate your very succinct presentation. Next is Jose Antonio Rivas, and he will give us perspective on the Comstor decision and other developments from the enforcement perspective. How would that how U.S. courts would view that, would view these developments. Please, Jose Antonio.
Thank you, Jean, and thank you for my co-panelists to frame the issue and care to provide your opinions, and also care to not always agree, which is very important for this type of panels. What I would like to do is to frame the issue in the following roadmap, and I'm going to put together to share the screen for a second, just so give me 1 second. Can you see it now?
Yes.
Okay, excellent, very good. So the main roadmap that I would like to follow is the very notion of an international rule of law, which I believe is at issue given the preliminary ruling in Comstory, and then ask the question, where does the ECJ get its power to adjudicate and interpret the ECT, and conclude that it no longer applies to certain member states of the ECT. And then I would like to go back into the enforcement proceedings in the US, because there's a very relevant element there. So just as a notion, I think that it's important to frame what the international rule of law would be. If we do a little bit of research in recognized centers of thought in Europe, Max Planck Institute, it has been said that an international rule of law would include consistent application of international law to states and other entities. And that would include respecting the decisions of international tribunals, which is central. Now, of course, I do not want to pontificate as to what the international rule of law means, but we all can refer to the heading of Article 26 of the Vienna Convention on the Law of Treaties, which specifically is called Pacta sunt servanda, which states that every treaty in force is binding upon the parties to it and must be performed by them in good faith. And there comes a key question concerning the ECT. My understanding, and I believe this hasn't been proven wrong, is that the EU Commission is a party to the ECT treaty. So there come a number of questions. The first question is, was there an exception when the ECT ratified? Did it say that the ECJ would be the authoritative judicial body to interpret the ECT? The answer to that is no, it did not. So in all given worlds, it is clear that by the letter and by the language of the ECT, the ECJ is not the authoritative adjudicator under international law. But let's be fair, because I think that my colleagues have raised some of these issues as well. So under EU law, or the question is, where does the ECJ get its power to adjudicate and interpret the ECT and conclude that it no longer applies for intra-EU disputes? Under the EU law, of course, as Professor Carducci has explained, under paragraph 23 of the Comstory preliminary ruling, there is an agreement concluded by the European Council, which forms an integral part of the EU law, and therefore and the ECJ has authority under EU law. But under international law, that is no longer the case. As I have said it, the ECT does not grant the ECJ that authority. So we are left in a world where there seems to be some sort of pseudo or quasi supra-international power of the ECJ, which based on a notion of respecting the international rule of law is wrong. Now, there are other questions that arise out of that quasi or supra international authority. What could other regional courts do if they start to follow the same example as the EU? It would be a true negative effect for the international rule of law, and that's why with regard to the title of the panel, I do believe that unfortunately the EU may be behaving as a recalcitrant entity. Let's move a little bit further into this. There's a few elements that both Professor Lavranos and Carducci have already referred to. I will not repeat them. The conclusion that Stylex contracts and transactions with Moldova do not constitute an investment is provided in the preliminary ruling of the ECJ. That is a question that the Court of Appeals of France posed to the ECJ. But what is very important to remind ourselves of is that at this present moment, the Stylex or the Comstroy award, which was an ancestral award, is currently an award that has been recognized by French courts. Why? Because yes, the award was annulled at the appeals court, but then that decision to annul the award was annulled itself by the Cour de Cassation, namely doing an exercise that the ECJ did not do, which was invoking the Vienna Convention on the Law of Treaties, analyzing Article 1.6 of the ECT, and indeed declaring that the transaction and the contract itself was in fact an investment under the ECT. And the Cour de Cassation went even further in indicating that the Cour d'appel had in fact included elements that were nowhere in the ECT, and specifically, and this wasn't said by it, some of the elements that were required by the ECJ relate to a jurisprudential development under ICSID jurisprudence, which is the Salini test, the notion that there should be risk, there should be development, and there should be also assets being promised to develop the investment. So, but here the Comstroy versus Moldova case is an ancestral case. It is not an ICSID case. So it begs the question, why would the Salini test would be included here? But beyond that, the Comstroy decision in Europe has not been annulled in itself. Hearings are scheduled for the 22nd of March of next year. And of course, many commentators are asking themselves, what will happen there? There's a strong belief that the Cour de Cassation will have no choice but reverse what it did before and follow through with the mandate of the ECJ, because ultimately it's sort of the Constitutional Court of Europe. That being said, let's turn into what is going on at this side of the Atlantic. And Nikos gives a solution in terms of a prospective solution, which is, well, investors should no longer constitute their investment in Europe and constitute their investment somewhere else, because now Europe is not, in fact, honoring the investment arbitration awards, which is true. At this side, I don't think that we have to. For future planning, that may be true, but for immediate effects, I do believe that some states are may have the tools to still enforce awards that may have been issued in European states, and not necessarily only ICSID arbitrations, which of course do not have that seat problem as others non-ICSID arbitrations do. So let's do a little bit of a recollection of what has happened in the States. For instance, in Mikula versus Romania, the Mikula brothers were successful before both the U.S. District Court for the District of Columbia and the U.S. Court of Appeals, which allowed the arbitral award to enter into judgment and be enforced. So that happened in Mikula. Now, in the Tao Lao versus the Lao People's Democratic Republic case, we have the opposite perspective. In that case, the court established that the award was annulled by a Malaysian court, which was a neutral venue that the parties chose by mutual agreement. In other words, it was not a case in which the seat court had favored by annulling the award a state company in that country. Additionally, the court stated that the Malaysian court annulled the award on the basis of a universally recognized ground, which was that the tribunal lacked jurisdiction. So we have sort of a one case went one way, the other case went the other way, and now we get to the very interesting case, which I believe may be very relevant for our discussion here, which is the Comisa versus Pemex case. In that particular case, the court concluded that the decision to annul an arbitration award by the Mexican court violated the most basic notions of justice and gave rise to Comisa's request to execute the arbitration award. Ultimately, the court analyzed that the Mexican court had upheld the annulment based on a norm that had entered into force after the conclusion of the arbitration agreement between the parties. So in a way, the decision of the Mexican court to annul the award was retroactive, and that was seen negatively as a sort of denial of justice. The court highlighted that the injustice of the decision of the Mexican court was aggravated by the circumstance that it left Comisa, the claimant, without any remedy to litigate the case again. So that's sort of the context. That's the context because this is where we could eventually go or be at some stage in the future. But we're not there yet, because unlike the decisions in Comisa, or unlike in the decisions of the Tao Lao case, and unlike in other similar US decisions, the Comstor decision today has not been annulled. Even though everyone presumes that that's where we're going. It may take, in the calculations of the US District Court for the District of Columbia, up until 2023 or 2024, until all the proceedings take place in Europe. So with that notion of longevity, what has happened in the US concerning the Comstor decision? Well, in the US, very recently, and this is really fresh out of the oven, 15 days ago or less than 15 days ago, the US District Court for the District of Columbia on 2029 of November decided to deny the motion to stay raised by the state of Moldova. And it did so taking into account several elements, which included what was the burden concerning the what was the burden for both parties if the decision to enforce the award would be stayed, and it concluded that after more than 10 years of the award being rendered, the stakes were very high for it to stay the enforcement of the judgment. And therefore, it denied such a motion. And it also concluded that unlike what had been argued by Moldova in US courts, the decision by, or the preliminary ruling in the ECJ would not be one which, as a matter of months, would lead to the annulment of the arbitration award. So those elements are very important, although the decision of the US court did not refer to the Comisa case or the Tao Lao case. Those are notions that are sort of under the water, and at some stage it could get there onto the question of whether there is a denial of justice by all the actions that are taking place by European courts with respect to existing arbitral international awards. So just to conclude, and to frame my remarks, I would like to say that that the position that investment treaty arbitration proceedings are at this stage and age no longer liked, or not only favored as a policy matter, has immense ramifications for public international law within Europe and outside of Europe. I was on a panel months ago where I heard arguments of African representatives looking into the Comstroy's decision and basically making similar arguments. Why should we now follow through with arbitral awards if Europe is not doing the same? The same thing could happen in Latin America. So the mere fact that the ECJ is putting forward these notions, and in my opinion, it's acting more like a domestic court than anything else, is extremely dangerous for the public international rule of law. And with that, I will stop my remarks. Thank you.
Thank you, Jose Antonio. I appreciate those indeed fascinating issues that the Comstroy decision is raising. There are a number of questions posted during our discussion, and some of them perhaps were alluded to or answered in some fashion, but I would appreciate just maybe reemphasize on one interesting point that was raised in the comments, is whether the French courts, if of course, as Jose Antonio mentioned, the CJAU issued the decision, and now a case is back at the Cour d'appel in Paris, and they will be hearing in March. Presuming that the Cour d'appel will follow the CJAU ruling, and then the cassation Cour de Cassation will uphold the ruling if there is an appeal, whether this type of French court decision would be inconsistent with the bilateral investment treaty between France and Ukraine. I find this is just absolutely fascinating questions. I would appreciate, Nikos, if you can perhaps re-emphasize and focus on that. Appreciate that. Thanks.
Sorry. Yes, now I'm unmuted. No, I mean, as I mentioned also in the chat shortly, I would say that indeed that would be a breach of the BIT, because of course the underlying idea of the BIT is that both contracting parties and all the organs are bound by the BIT, and the arbitral awards following from such tribunals established under those bids. So not following that, I think, is a breach, because it's in effect a denial of justice. But at the same time, and that is exactly what we are doing today in this panel, from an EU law perspective, obviously, the supremacy of EU law requires all domestic courts in the EU, including the French courts, including the highest French court, to what I put in quote unquote, implement the Comstock decision. I mean, that's the same what the German Bundesgerichtshof had to do in the Achmea case. When the Achmea judgment came out, it simply rubber stamped the judgment of the court in Luxembourg and annulled or set aside the award. So there is no way, I think, for the French courts to escape. And actually, I would assume that even the European Commission would start infringement proceedings against France if French courts would not follow through. But from a PIL perspective, from a BIT perspective, I think it's a very, very interesting point, and could even raise the issue of an FET violation.
Yeah, of course, the facts of the Comstock case are much more complicated than simply what was described by the CJEU in one or two paragraphs. So to that end, there could very well be possibility that the French courts would address these facts and find that there was not simply a simple contract for the trade sale of electricity. That's of course another possibility. But regardless of that, I think it's just fascinating question that thinking about the U.S. approach. And of course, there's an ancient case. There's a very old case at Paqueta Cabana in the United States, the U.S. Supreme Court case that says that the international law is part of the U.S. law. Does it mean that the cases involving international law that are held, that are heard in the United States, and they are, of course, because of course, I don't think anyone disagrees here that if the arbitration is held in a particular jurisdiction, the law of that jurisdiction applies. It's indisputable. But at the same time, if the issue involves interpretation of international law rather than the domestic law, wouldn't that be more appropriate to address this issue based on the principles of international law rather than the principles of domestic law if these principles are inconsistent with each other? And that's the tension that I see, at least in the situation that with the Comstock. I see that Jose Antonio wanted to add something.
Thank you, Jean. I'm absolutely in line with your suggestion that that principles of public international law should be applicable. Now, what is so fascinating about the Comstock decision to me is that we've had two very high courts, the Cour de Cassation in Paris and the ECJ itself in its preliminary ruling, having opposite views. The Cour de Cassation being the highest court of France, which basically sided with Comstock, indicating that that a reading that required more than a contract or a transaction concerning the sale of electricity was a reading that went beyond the language of the ECT, and it is there for your reading. And then the ECJ basically making arguments that are not grounded on the language itself of the ECT. You look into the treaty and you look at one way, you look at the other, and there is no reference to commercial transactions. There's no reference to exceptions of commercial transactions. There's nothing in the treaty that you could rely on to get to the conclusion. So what's so interesting is that two very high courts got to a different conclusion. Of course, the Cour de Cassation will have to yield.
Jose Antonio, you are muted.
Oh, okay.
Just 5 seconds ago.
That is why the fact that we have two very high courts in Europe opining differently shows the reason why domestic courts, and here I'm assimilating the ECJ to a domestic court or a regional court, domestic courts should not be the adjudicator of a treaty because they are party to it. And the treaty does not give those parties the right to interpret as an authority under international law.
Thank you, Jose Antonio. I see that Professor Carducci is raising his hand, and I'll give him 3 minutes, and because we already ran out of time, but I certainly would want him to reflect on this discussion at the end.
Yeah, thank you, Jean, and thank you to all the co-panelists for interesting discussion. I mean, of course, these are very complex matters. It's only regrettable that we have so few minutes, because then we remain on superficial positions. We don't have the time to elaborate. Anyway, that being said, very quickly, I can only, unfortunately, I can only disagree with some of the statements by our distinguished Professor Lavranos. I don't have the time to develop, but when he says that the EU member states terminate also the Energy Charter Treaty, that's I'm afraid unsubstantiated. Absolutely, that's absolutely not the case in the agreement. First, second, when he says that a constroy excludes the benefit of Article 26 2C for any state beyond the EU member states, that's also, I'm afraid, unsubstantiated and contrary to the simple reading of paragraph 65 and paragraph 66 of the judgment. I've not been expressing my views, absolutely not. I've been here reading what the court said. I'm not adding or subtracting anything. It's not about my views. It's about what the court said, especially having only 15 minutes to deal with all of this. Then as to the use of terminology, and the court is not adjudicating the Energy Charter, it's interpreting it, which is different. One of the points is whether the court could do that, and already told you that in principle, the mandate of the court is on the interpretation of EU law, and I already said that the multilateral treaty, it is not formally part of EU law. That's the real point. And then the answer to that, you find it in the paragraph 23 of the judgments, the one I read before. So again, as far as I'm concerned, I've been trying to be informative with less theories. I provided to those kindly listening to us, what the court said. I'm not adding much because we don't have time to elaborate. So I'll stop here. Thank you.
Thank you very much, Professor.
If I may, Jean, just make a 30 seconds point.
Okay.
I think after listening to my dear colleagues, I reached the final conclusion that these issues escape the realm of international law and EU law. This is more related to policy and politics playing with issues related to international investment law. And that, I think, is the main problem. This is trying to reach a final point and trying to address the issue as a legal point. But I think, sadly, for international law, this is just a justification to reach what it's in the minds of the EU public officers for many years now, and trying to reach that final determination. Thank you, Jim.
Thank you very much, Alvaro. And it was a fascinating discussion. Thank you, appreciate it. Input of all the speakers. And that we'll be finishing our panel, our discussion.
Thank you so much.
Thank you so
Jean.
much. It
And
was a great pleasure.
Thank you, everybody,
Thank you.
for joining us for this panel. Of course, to the panelists and the moderator, it was a real pleasure learning from you in this exciting topic. So now we will be going to the breakout rooms so we can have a little bit of networking. Thank you, everybody.
Bye-bye. Thank you.